Well, thank you for that very welcome introduction, and good evening, ladies and gentlemen. It's a great pleasure to be asked to give the second EFILA lecture in Brussels, because in its short life, EFILA has made a very significant mark in the growing debate over foreign direct and indirect investment, investment protection, and investor-state dispute settlement, or ISDS, not limited to the European Union. And as for Brussels, I first visited the city when I was 6 years old, and I'm always delighted to be back in a place I once knew so well. Well, on any view, this has been an eventful year for both the EU and the United Kingdom, with events compounding common difficulties, or as politicians like to say, creating new challenges and opportunities. But it's nonetheless hard to keep smiling with this morning news from the United States. We may face new and terrifying difficulties in Washington, equivalent, and we don't know which, to 1848 or 1933, of which internationalism, international law and free trade may be very severely tested. But we can't talk about that yet tonight. Coming nearer to home, we've seen the EU's near inability to sign CETA with Canada, along with the EU's continuing inability to sign the proposed treaty with the Ukraine, the EU's effective abandonment of TTIP with the USA, at least for the time being, and the prospect of opinions from the European Court of Justice next year, not only upon the legalities of the EU-Singapore free trade agreement, but now apparently on CETA also. So as a result of all this, there are now grave uncertainties over the EU's current negotiations for trade treaties with 20 or so other countries around the world. Now, why did we suffer, and why do we still suffer, these near-death experiences in regard to extra EU trade treaties, once regarded as so essential to foreign trade by individual EU member states, but now increasingly derided by many of those same states and civil society across the European Union? If we listen to the most strident critics of the EU's new trade treaties, it is ostensibly due principally to ISDS, as in their words, the malign existing system of arbitration for the non-national settlement of investment disputes between states on the one hand and powerful profit-driven international investors on the other. Thus, the French former Minister of Economy, Arnaud Montebourg, recently denounced CETA for many reasons, of which he said the principal danger, le principal danger, was its proposed arbitral system. So too one of the reasons given ostensibly by Wallonia for its recent attempts to veto CETA. So equal to the threat to its beef farmers, so it argued, was the risk posed by ISDS in CETA, permitting large foreign companies to claim damages for laws and regulations made by elected governments and national parliaments. The paradox is that CETA's ISDS was intended by the EU and Canada to be a new and much improved system, free of many of the criticisms of the so-called old system of ISDS in the form of ICSID or UNCITRAL or international commercial arbitration. Indeed, building on the successful CETA negotiations and apparent progress in the TTIP negotiations with the USA, the European Commission had indicated that it now saw the future of ISDS not as its own bilateral system to be agreed with each of its intended treaty partners, as it had done with Vietnam, but rather as a new multilateral international investment court system open to all states at all times, whether or not in a treaty relationship with the European Union. Now, this was a radical idea that gathered much support within a short time, not limited to the European Commission, but including UNCITRAL and ICSID itself. And to that end, as you've heard just now, two distinguished scholars in Geneva were commissioned to prepare a report for UNCITRAL on how that multilateral system might be achieved by states, not only for new trade treaties, but also for existing bilateral investment treaties and free trade agreements. And that detailed report by Professor Gabriel Kaufmann-Kohler and Michele Potestà was published in June 2016. It is an excellent blueprint for a possible multilateral international investment court based on the freestanding opt-in model of UNCITRAL's Transparency or Mauritius Convention. But this is on any view an ambitious, complicated and long-term project, and as its authors and others acknowledge, it is confronted by many formidable obstacles. The first of these is the general public antagonism to any form of trade treaty, whatever its contents. Such blanket hostility to globalization is now shared in many countries, including EU member states, and of course now the United States of America. It now seems certain that the USA will not ratify the TTP with its specific partners. And even if the EU were willing to conclude the proposed TTIP with the USA, it now seems certain that the USA will not do so because of the result of the presidential elections early this morning. Now, arbitration specialists like us are not economists, we're not trade negotiators, we're not political psychologists or analysts, and I'm no exception. And so for now at least, we must therefore leave aside this major difficulty. We cannot answer criticism based on rank prejudice, misinformation, and raw populism, where those critics have deliberately closed their minds to any form of ISDS. The second obstacle is a particular antagonism to any form of ISDS, including any new international investment court as proposed by the Commission. And this hostility is also visceral. However hard we may try to explain the necessity for some form of ISDS in an international legal order with all states subject to the rule of international law, this hostility remains persistent and unqualified amongst many parts of civil society, including EU member states. For several of these hostile critics, ISDS is also the proxy for globalization. It's certainly much easier for populist politicians, NGOs and pamphleteers to attack ISDS as a concept than to trawl through the quotas, tariffs and annexes of any trade treaty. Yet like a constant drumbeat, these repetitive slogans and caricatures attacking ISDS gather momentum to the point where rational dialogue has become almost impossible. Again, as arbitration specialists, we can do little in the face of such blanket hostility, and we must therefore, for now at least, move on. The third obstacle is largely self-inflicted, particularly with statements made by the European Commission, including Dr. Malmström, the European Commissioner for Trade. For a distinguished Swedish academic figure, and now a senior European civil servant, but manifestly not a lawyer, still less a diplomat, the Commissioner has used surprisingly extreme language to condemn the existing or old system of ISDS. For example, the Commissioner wrote publicly in May 2015 that, and I quote her, "My assessment of the traditional ISDS system has been clear. It is not fit for purpose in the 21st century. I want the rule of law, not the rule of lawyers." And in September, she said, "There is a fundamental and widespread lack of trust by the public in the fairness and impartiality of the old ISDS model. This has significantly affected the public acceptance of ISDS and of companies bringing such cases." I would query, as others have, whether the current system of ISDS is in fact old. I don't understand this attack on lawyers. And I do understand that the Commissioner has contributed herself to this perceived lack of trust in any form of ISDS. Now we can understand readily that the Commission is in a very difficult position, having to fight battles on two fronts. There are some figures within EU institutions who oppose ISDS in any form, including investment protection, and there are others who see both as essential to inward and outward investment. Yet these politically charged and recurrent condemnations at a high level have made it hard for the European Commission to defend ISDS, however much improved or disguised in new clothes. CETA's new international investment court therefore remains to its critics in civil society, including of course those in Wallonia, an unacceptable form of ISDS, designed still to produce an arbitration award enforceable against the state under the ICSID or New York Conventions, inevitably with the involvement of those lawyers. And as Judge Schwebel, a much respected international jurist, has aptly commentated, this institutional appeasement by the Commission has successfully appeased no one. But again, as arbitration specialists, we can do little by ourselves to counter these criticisms based on misinformation and misunderstandings. First, we merely provide a service to others. It may be, we think, the best service in the world, But if users and states don't want it, so be it. Arbitration takes place by the parties' consent. We cannot compel any users to choose arbitration, particularly states. Like coal miners, if no one wants to buy our coal, even the best coal mine must close. And arbitration specialists are not a religious sect or a militant trade union. There's no institutional formal organization to defend them. If users, whether states or investors, choose not to defend us, how can we successfully defend ISDS as individuals? And last but not least, the answers cannot now properly come from us, as specialists in the existing form of ISDS, or even arbitral institutions and their secretariats, such as ICSID, the ICC, or the Stockholm Chamber of Commerce, because we all have, it seems, a direct self-interest in maintaining the existence of this old ISDS. We are, in the eyes of many, a dodgy lot. I need only cite a passage from a well-known academic textbook, now in its 6th edition, by a distinguished European professor who has acted as an arbitrator in both investment and commercial arbitration. And he said this just a few months ago: "Undoubtedly, the standing of the international arbitrators has been damaged by their exalted idea of themselves, their covetous attitudes and craving for new cases, and by the bureaucracies that surround them." He's talking probably about ICSID and the ICC, where there may be a symbiotic relationship that threatens them both. Arbitration is a business, and it is in the nature of all businesses to strive for monopolization. Amongst an insider crowd of arbitrators and law firms, at first much manifested in ICA before its opening up, which made it a jamboree of arbitrator hopefuls and insignificant at the same time, cross-appointments and mutual advancement became common in the various secretariats, if not also in the courts of the established arbitral institutions. These secretariats and institutional courts, which may exert great power of appointment and the handling of cases, often at the invitation of arbitrators who have too many, are like all bureaucracies characterized by 4 features. A, they want more power and influence. B, they do not want liability for their action. C, they gravitate towards the lowest common denominator. And D, they leak like a sieve. Now, the issue is not whether his views are correct, or as I believe them to be, materially and grossly incorrect. The issue is that these views expressed by one of our own are widely shared by others outside our community, including, I regret to say, parts of the European Commission, and that by constant repetition, enlargement and exaggeration, they now constitute for ISDS specialists a fact of political life. In short, presumed alcoholics working in a brewery are not the best advocates for teetotalism. Now, faced with such great obstacles from so many critics to any form of ISDS, it seems likely that the Commission's initiative for a multilateral international investment court will take many years, if not decades, of negotiations to achieve its intended result, if it succeeds at all. With the necessary involvement of states from around the world, the design of this proposed court will require extreme care to ensure a genuinely new and transparently fair and practical system, not only for civil society and host states, but also for all its users, including, of course, foreign investors. Now, this is not the time to discuss an exercise which would discourage even Sisyphus. So tonight, what I would like to do is to explore one aspect of the Commission's initiative, the establishment of a permanent international investment appellate court. Now, at this point, we need to step back far away from ISDS and forget that we're interested in any new or disguised form of ISDS. We need to look at 3 factors relevant to any appellate mechanism: the perception of justice in the particular case; second, the consistency of the decisions resulting from that process; and 3, the legitimacy of the process as perceived and accepted by civil society. So I start with justice, again a non-ISDS case, which illustrates the point, I think, quite clearly. It's a case of injustice from Massachusetts, which has royal civil society and public opinion in New England, and it's known as Deflategate. It has, as I